Hi, everyone. My name is Aaron Goldblatt,
And I'm Marco.
and this is episode one of our podcast where we're going to talk about a very important law in the U.S. Federal Code called Section 230 as part of Title 47. As you can see, we have kind of the text of it on screen. And what's so interesting to us about 230 and why we kind of decided to make this podcast talking about it is that despite it being a very fundamental part of the legal code and a very fundamental part of how the internet, which is such a big part of all of our lives, developed and became, kind of the important foundational society changing thing it is today. Um, it's this law and its particulars are actually not too well known. People don't really seem to know about it so deeply.
Right. Interesting enough, Aaron, I've never heard of Section 230 before the research for this podcast.
Right, right.
Yeah, it's quite interesting. Could you like sort of also just walk us through what Section 230 actually is and sort of where it came from? Because to me, it's a very old act or old law that was passed by the Congress, right?
Right. Yeah, for sure. So the kind of basis of Section 230 um, is it all kind of stemmed from like what the case was before it, because at the time when it was established, at the time when it became a thing, uh, before that there had never really been any kind of legal framework that the internet operated in, because at the time the internet was like kind of a new concept. And it wasn't really, it was something that was more for hobbyists, for people who kind of like were very technical, and it wasn't the kind of the major thing it is today. At that time it had been like developed slowly by the government, by the Department of Defense, and then kind of ultimately became sort of a hobbyist technologist's project. But really, the legal kind of framework that preceded 230, which was kind of the early internet, and then what led to 230 becoming a thing, uh, were really two court cases that centered around kind of the early internet. So more broadly, to like kind of describe what the internet looked like at the time, the internet had like kind of a few different service providers, and they were each kind of siloed into their own area. You had stuff like America Online, CompuServe, Prodigy. These were different kind of like web servers, like different kind of providers that would serve like web pages and like places for people to talk. And these each of them kind of ran their own like little kind of internet sub area. And the initial kind of legal troubles with some sort of the unanswered questions of the internet stemmed from these things. I don't know, Marco, when you were a kid, did you ever hear like them talking about like America Online keyword something? Or like do you have any memory of that?
I have absolutely the very crude memory that I have of early internet. To be frank, I don't have any recollection. I think the first website that I've ever visited was Yahoo.
Yeah, right.
And this was
Which has
already
since
pretty
become
like,
basically just like a finance and sports.
yeah, but that was still already like pretty like late or like
Right.
early 2010s, maybe. Yeah.
Right. I feel like when we, because I guess we're younger, when we like kind of entered the scene of really going on the computer and going on the internet was already more of like an established thing. You had like websites
Yeah.
and Google and stuff.
Yeah.
But
Yeah.
back in the day, it seems like from talking to people and from like the research that we've done, it seems that like the internet was really more of like a hobbyist thing and was really used a lot for like chatting and DMing and
Mm.
stuff. So this kind of speaks to where 230 started. So the initial court cases that prompted the creation of 230 centered around whether these internet providers, these service providers, like I mentioned, CompuServe, Prodigy, America Online, whether they like how like it was kind of an open question how responsible they were for content that was put on their platforms. Because with the traditional kind of media, the traditional kind of platforms, you had like, news, like newspapers and TV shows. It was always a very like kind of centralized thing. And it was always very like edited. And it was pretty obvious that it was being seen as something like a publisher, like a book publisher or like a newspaper publisher,
Right.
where since the newspaper maintains a lot of editorial control, it should be responsible for the things that it says. Uh, a newspaper, for example, could be sued for libel or whatever if they lie about someone knowingly or whatever it is. But the internet, because it was so interactive and because it had kind of such a, in a sense, democratization of like information and information providing, it was really like a very different thing, and it was kind of no one was really sure where it stood. So the two court cases that we should really talk about are this first one is Cubby versus CompuServe, and the the specifics of the case like ultimately resolved to basically saying that CompuServe was a like so the different like platforms had different kind of like ways that they would approach content in the early days, and the two kind of extremes that are important to know is CompuServe was like very like free for all. Like they didn't do any sort of editing. It was just kind of they left it the way it was, and that was how it was. And like whatever users are put on there was on there. There was no editing of
Right.
content. There was no taking things down. And then Prodigy, in the meantime, marketed itself as we're a family friendly, web provider. And all of our
Mm,
sites are moderated. We take down offensive content. So both of these two providers were sued for illegal or allegedly illegal things that showed up on their platforms. And although neither of these lawsuits really went anywhere in terms of like the actual people who sued getting money or whatever it was, the law that came out of, or the interpretations of the law that came out of these lawsuits were very important. So the Cubby versus CompuServe had to do, I believe, with like a libelous like type thing in with CompuServe, that like there was like someone who was like libeled on like from defamatory statements in a certain like a certain web page or whatever it was in CompuServe, and he sued. And the main thing to understand about that case, without kind of diving into like the nitty gritty of it, is that because the CompuServe was a very hands-off company, it was basically said that under free speech rules, under First Amendment rules, since they're serving as a very passive conduit for information, but they're not actually doing any sort of editorializing, then that is, that speech is only like that speech is considered to only have come from the person who was writing it, and it's not CompuServe as the one who is serving that content can't be held liable for it. And then the kind of opposite case was Stratton Oakmont versus Prodigy. Marco, you've seen Wolf of Wall Street, the movie?
yeah, yeah. I feel
Yeah,
like
great
that.
movie.
Right. Isn't Stratton Oakmont the company that Jordan Belfort founded? Was that
Yeah, so
the
Stratton
name?
Oakmont was that like stock firm on Long
Right.
Island, that was, busted up in this whole, like, you saw if you saw Wolf of Wall Street, like more or less
Yeah.
the story. It's more or less based on the true story of him kind of like doing a bunch of fraud and like
Yeah.
gamifying the stock market and eventually getting caught. I had a teacher in high school who worked for him. He was like a grunt who was just answering phones at the company, and he was there when the like Jordan Belfort got like dragged out by the FBI.
Oh,
Pretty
really?
crazy. Yeah, yeah, it was
Dang.
pretty wild story. And now he teaches, history at my high school. But in
Nice
any event,
transition.
shout out to Mr. J. But in any event, the this company, Stratton Oakmont, and the whole story of Wolf of Wall Street actually also pertains and had a really significant effect on internet law, because they were responsible for this case, Stratton Oakmont versus Prodigy, where Prodigy was this other web server. And basically, after Daniel Perush, I think his name is Daniel Paresh. Let me see if I can Google a picture of him. Daniel Parash, who was played by Jonah Hill in the
Mm,
movie, who was kind of like the partner for Jordan. He was essentially possibly libeled on this Prodigy, website, where someone essentially accused him of breaking the law and like committing fraud because they IPO'd a certain company, and then that company it turned out had lost like its biggest customer that was responsible for like a ton of its revenue. And this happened like right after the company went public. And someone basically went on this Prodigy forum and started posting all these things, basically saying like he's a crook, he's going to get arrested, what he's doing is horrible, and he and Stratton Oakmont sued for defamation and libel. And although the court case never went anywhere because like Prodigy ultimately just issued an apology and he dropped the case, the case was very significant because Prodigy wanted to kind of be like CompuServe. We're like, oh, we shouldn't be held liable. But the judge in that case said, hold on a second, you market yourselves as a family friendly website. You market yourselves as taking down content
Mm-hmm.
that is problematic. That means you're a publisher. You're a publisher. And kind of in the long-standing legal frameworks before that, stemming from even like Elazar Smith, like a case concerning a guy named Elazar Smith and his bookshop where he was sued for kind of carrying material that was considered obscene at the time, like books with like erotica in them. And he basically said, I can't be responsible for every single book that comes through here. Um, he, Building off of that law, the case law in those cases, it was seen that Prodigy couldn't make that argument because they publicly professed themselves as a company that did editorialize.
Mm-hmm.
And that led to this decision kind of being like, oh, internet companies can actually be held responsible if they do moderation of any kind. They can be held responsible for content that they post.
So,
Um,
sort of in
yeah, you're saying.
summary, basically the two cases, Cubby versus CompuServe, Sean Oakmont versus Prodigy. CompuServe was a server that didn't really do any editation, didn't do moderation, whereas Prodigy, although the case was dropped, if probably if they went to court, they would have lost the case. Is that what you're saying with like the past historical like the past history of cases, publisher versus like editor, I guess, or yeah, is that would
Yeah,
that be
yeah.
the
So the
case?
idea is the idea is like at that point, basically the case law became, and this was a case on Long Island. This the Prodigy case and stuff. Just seeing if there's like you can see like America Online and like this is kind of what they looked like. Bix. This is CompuServe. You can see it looks
Mm-hmm.
like pretty. It's pretty OG.
Mm-hmm.
Let's see if we can find Prodigy anywhere. Is this Prodigy over here? No. Oh, here we go. This
Oh,
is what
here we go.
Prodigy looked like. So these were like very old systems, but the idea, like you said, is that it was basically seen as you moderating or you kind of taking any editorializing over the content that you serve as an internet company could open you up to liability. And
Right.
this now that sounds like kind of reasonable. No, like do you think that sounds like reasonable? Like if you editorialize, you should be responsible?
Yeah, I feel like that does sound reasonable. I do, however, wonder what actually are the laws that, what is like sort of the specific law that is being passed under Section 230. Did it
Right.
specify saying that if even if you were to moderate, you're not liable? Yeah.
Yeah, exactly. So basically, the story goes that basically there's a guy named Chris Cox. Chris Cox he worked in the Reagan administration. Um, he was a congressman for many years. This is what he looks like. And this guy,
Hmm.
Chris Cox, he read in a newspaper while he was on the plane from his district to DC. He read in a newspaper about this Stratton Oakmont case. And he was kind of a more tech savvy guy, was familiar kind of with how the internet was developing. And he was shocked by this because his thing was this law kind of creates what he viewed as kind of a ridiculous paradoxical situation
Hmm.
where if we want the internet to be a safe like place for people to go on and be able to Google things and be able to interact with the internet without coming across like horrible content or pornography or like extremism or like insane like stuff that people wouldn't want to see. Um, how are you going to have an internet that people are going to want to go on if you're not going to basically allow companies effectively to moderate? Because
Right.
if companies have no say over moderation, because any say over moderation will cause them to get sued and be actually culpable for being sued, culpable for serving kind of illegal or problematic content, then that's going to either incentivize them to A, not accept any user content, so just not even let users participate, and then it's no different from TV or newspapers or radio that
Right.
came before it,
Right.
or they are going to let people, but they're going to basically either be responsible for every little thing and be sued, or it leads to like this crazy situation where or they are totally hands off. Like the two main like things that the two like realistic decisions most companies would make is either don't allow user content or to just not moderate, and then you just have
Mm-hmm.
like anything goes wild west internet, which he
Mm-hmm.
saw as both of those are problematic. And ultimately you
Right.
wanted something in between where you have like a lot of you're able to get a lot of diverse viewpoints and things that like interaction on the internet, while simultaneously it being a safe place for like kids and people to go and interact with without having to be exposed to kind of craziness. And Chris
Right.
Cox at the time was very good friends with another uh, with actually a Democratic congressman named Ron Wyden. This is that guy, and him and this is him, Ron Wyden. There's a better picture over here, and these two guys were actually, even though they were on like literally opposite ends of the political spectrum. Chris Cox was like a more conservative Republican. Ryden was considered a progressive Democrat. They were actually very good friends. They would meet up for lunch all the time, and they always had an idea that they wanted to kind of try to, because as you might be familiar with, Marco, there's a lot of like legislative deadlocking that happens in the U.S.
Right.
I think by design, but because there's so much deadlocking, not a lot of it's very hard for legislation to get through. And their idea was to kind of, when they would meet up, they would try to focus on bipartisan legislation that they thought weren't kind of like settled issues, like something like,
Mm-hmm.
let's say, like abortion or I don't know, gay marriage, any like pick any like kind of big hot button political topic. A lot of them, both sides kind of they're fighting with each other, and it
Right.
just kind of ends up in a deadlock because neither side can agree with the other. But if you
Right.
bring up kind of new emerging situations or new emerging legislation that covers something that's not like settled politically, you can often kind of have a lot more movement on that. And that was kind of what they were doing with the internet. So the two of them had discussed this case that Chris kind of brought before them, and they realized that this Stratton Oakmont thing was kind of ridiculous. They both kind of viewed the internet as being very important and being a good tool to bring America forward, even though at the time it was considered a very small industry. Like there were very few players. They weren't like really that big. The whole user base of the internet was in like the I think tens or hundreds of thousands, which is crazy to think about now. Now we have like
Mm-hmm.
literally billions and
Yeah.
billions of people on the internet and so many websites. But like it was just a very different time. But they kind of had a very good foreknowledge, for like insight that this could become something really huge, which
Mm-hmm.
ultimately history has proved them correct. So they basically got together, and the two of them, the time that it took place, that they were coming up with these kind of like these ideas and came across this issue. It was around the time where Congress was already kind of revising a huge telecommunications kind of they were kind of basically just going over the telecommunications law, and they were kind of changing it and adding stuff and taking stuff away. So it was very like kind of big time legislatively. And basically the two of them only had like a few weeks to get in. If they wanted to add some sort of amendment that covered the internet, they needed to basically come up with it really fast. So the two of them basically worked nights, and they like called in like activists, like technologists, people who are like good with technology, and they ultimately drafted the law that we know as Section 230. And then its kind of history as legislation was really interesting, because when they introduced it to the House and they added it to the legislation, to the telecommunications legislation, it was a very like no one really argued against it. Like at the time, the internet was so not a thing that people, either the congressmen did, like Congress people didn't either didn't even know what it was, or if they knew, they didn't really like have a settled opinion on it. So Section 230 just seemed like, oh, this kind of makes sense to them. And then what's interesting is at the time, there was another congressman who was also trying to pass something which was kind of wildly different. The other kind of end of this, it was a guy named James Exxon, um, who was a very conservative Christian, like a very like kind of right wing conservative guy. And this guy, his kind of goal was to he was really furious about pornography, about porn on the internet. At the time, like the pornography industry was becoming like bigger and bigger as like the Supreme Court and federal law in general was taking a more like pro free speech view and was like basically allowing things that could be considered artistic and whatnot. So this guy was horrified by pornography and particularly horrified by it on the internet. He actually, this is funny, in the book that I read, which is actually, it's a great book, The 26 Words That Created the Internet. This book by like a lawyer talking about Section 230 and the history of it, Jeff Kosef or whatever his name is. It talks about how this guy used to have a little booklet that he printed of internet porn. Like he had an entire book, and he would go around to different legislators and show that and like force them to read this book to be like, look how horrible the internet is, which is a pretty weird thing. It's a pretty crazy
That's
thing to be
weird
doing. Now,
lobbying for sure.
yeah, I'm surprised he didn't get like arrested. I feel like that's like not okay to be shoving your porn book in everyone's face. But nonetheless, that's what he did. And I guess it was pretty convincing because people kind of agreed with him, like, oh, this is like a big problem. We need to kind of tone down the internet. It's all just,
But did his bill get passed, or was it even brought to the floor?
yeah, so his bill actually got passed. Yeah. So when Section 230 got passed, this bill also got passed. So both of
Interesting.
them were kind of passed in tandem and both added to the legislation. So his bill, the text of it basically said the Exxon like amendment basically said that you want to hold you would it would impose strict fines and I think even jail time on anyone who knowingly hosts or provides content like obscene content that gets shown to a minor. Now, while at its face that
It does
sounds
make sense,
reasonable, like no one wants to
right?
be
Yeah.
showing porn to minors, hopefully. Um, the way that it did it was extremely vague and it was just bad. It had clear
Hmm.
First Amendment issues. But it was almost like kind of seen, I think, at the time in Congress as like a quid pro quo, like, oh, we'll put in the Section 230 law, and we'll get into like the text of it and what it does. But we'll put in the 230 law, which was a more pro free speech esque law, and then we'll also put in this one to deal with the obscenity and
Balance it
problems.
out, I think it's more striking a balance.
Exactly, that was their idea.
Right.
And then this bill actually passed overwhelmingly. It ultimately, because bills in the House and Senate, I don't know if familiar are with kind of the civic stuff. Are you familiar with kind of the workings of the House and the Senate?
Yeah, I mean, I think I have a good grasp
Like a good, like
from
kind
my
of like basic
knowledge.
knowledge.
Yeah,
Right, yeah, but to go over
from
for
what I know, I think it's whenever a bill is being proposed, it goes through the House first, and then if the House passes it, it goes to the Senate, and then if the Senate passes it well, then it is um brought into
signed by the
effect, I guess.
president. Yeah,
Yeah,
and then
signed by the
becomes
president.
like
Yeah,
becomes bill, right?
right.
It's like that. You remember Life of a Bill? I don't know if you saw this as a kid, where they show that Life of a Pill video. It's like this little video of like how a bill becomes law. This video where they have
Nah,
like a
I
little
haven't.
bill and it dances and sings, like, all that stuff. But regardless, yeah, that's the basic kind of premise. So here, and then either I think the House has to start any budgeting legislation, but if it's like basic legislation, it can kind of come from either house, but they have to ultimately kind of agree on it because both houses have
Right.
to pass it.
Yeah.
And this actually, even though this used to be kind of standard, this is a bit of a tangent, but this has actually become a bit of a unique thing about America. Because most countries now do not have this. They don't really have a bicameral legislation at all. And if they, legislature at all, and if they do have a bicameral legislature, usually one house is primary, and then the other one doesn't really have the same powers as the first one does. Places like the
Right.
UK and parliamentary democracies.
Right.
But in the
Interesting.
US, both houses have to pass it, which means that any legislation you're going to have to, you're going to have to go through
Lobby
both
both
houses. You're going
sides.
to have
Yeah.
to, yeah, you're going to have to get both houses
Right.
to agree to it.
Yeah.
So both houses had to kind of sign off on this, on this. So what happens is once the bill is passed by the House and by the Senate, then there's a committee called like the like a conference committee where they'll conference and they'll kind of iron out both bills into one bill, and they'll kind of fuse the House bill and the Senate bill and make one bill, and
Mm-hmm.
then both houses will vote on that bill, and then that'll be the
Mm-hmm.
bill. So it was a worry like 230 has to be included. So during those conference negotiations, neither of our two congressmen, Chris or Ron, were a member of that conference thing. But there was a guy, I believe his name is Rick White. Rick White was a congressman. This fellow, this Rick White guy, he was in the conference committee and he was a big fan of the 230 bill. So this guy basically went to the conference committee and he ensured that it got in. And he said a lot of like you said before, Marco, a lot of how he got it in was by kind of saying that it would go in with the Exxon amendment. That kind of convinced like the more, I guess, people who are worried about
Mm-hmm.
obscenity and pornography and whatever to also go with this more free speech bill. And then ultimately they were both passed. I think the year that it was passed is 1996. Is part of the Communications Decency Act, so the Communications Decency Act encompassed Exxon's law and a bunch of other like obscenity laws, and then also the actual Section 230. And then that was passed in 1996, which was a part of a larger telecommunications,
Right.
deal. And it's
Actually,
interesting to,
yeah.
yeah, you're saying?
No, I was gonna say, could you pull up Section 230 and we could actually see what it is actually about, but finish what you were trying to say.
Yeah, sure. We'll get into it. But it's just interesting to think that at the time, the internet was so not a thing. People like didn't really care about this law. Like a lot of the Congress people didn't even focus on it. They were all focused
Mm-hmm.
on phones and on TV. Like that was like the big thing that they were arguing
Right.
about. Those were the big industries. This law went largely unnoticed for a long time. And ultimately, it was part of a U.S. code with this Communications Decency Act with all these Exxon laws and stuff. And those eventually made it to the Supreme Court, where they were immediately struck down and as unconstitutional. And it was actually struck down 9-0. So all of the justices in the Supreme Court agreed this law is really bad. It needs to go.
Interesting.
But they allowed 230 to stay. I think there's a legal process to
When
refer
was
to that. I'm
this?
trying to remember. Say it again.
When was this?
And this was the court case was called Reno versus the ACLU, or the American Civil Liberties Union. It was in 1997. So this was a year after the law was passed.
Oh,
Immediately, all the parts of it got knocked down. And then basically the only thing that survived from this Communication Decency Act was Section 230. So that's kind of the legislative
interesting.
history of Section 230. That's how it went in the legislature. And now let's go through it. Well, I mean, we're not going to, read it super in depth. Well, let's go, like you asked, let's go through it and kind of talk about the different provisions of it and what they mean. So
Yeah.
230, just to give like kind of a little brief overview of what it says, the real key part of it is C1, this little part right here. This is kind of the really big, earth-shattering part. This is what is often called the 26 words that created the internet. No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. And what that's basically saying is that internet platforms or interactive computer services cannot be treated like they are editorializing, like they're a publisher or a speaker under kind of First Amendment law of information that's provided by
Mm-hmm.
other people using their service. So it's basically saying that, like,
Mm-hmm.
for example, Facebook can't be held liable if you or I post something really illegal or horrible on Facebook. And this was this was basically, it was basically directly overturning the Stratton Oakmont case. It was basically
Mm-hmm.
saying that case does not count anymore. Like now
Right.
you have to give them a lot of leeway. And
Right.
this is a pretty exceptional thing. Like this is not, at least in the legal framework as it currently exists, this is not a guaranteed thing. This is not like a right that these companies have. This is kind of like almost a super First Amendment that's being granted by Congress to the internet industry because they see such potential in the interactivity and the economic potential and the way that everyone gets to participate and everyone has a voice on the internet. They saw this as very important to the ethos of the United States, and they opted to have this be a protection. And very few other countries have this protection. Canada,
Mm-hmm.
Europe, all those countries, platforms are to pretty large extents held responsible for things that they put and can even be like sued, can be, liable. And that's one of the reasons that of all the top internet companies, they're all here. They're all here.
Hmm.
That's arguably,
That's
Marco, why
very
you and I
interesting.
are looking for
Yeah.
jobs here because it pays the best. But
But I also think, I think yeah, C1 is the cornerstone of like the internet up until this day. I also think that C2, the civil liability statement is also very important, right? Because
yes,
I feel like with the free speech, right, being the cornerstone of the U.S. entire U.S. The country, right? It's one
right,
of the first bills that were being passed by the founding fathers. Um, being I think this is sort of going against that, allowing companies or freeing them of any liability of any moderation when, restricting content, removing posts or messages posted by the user, that which is going against free speech. Um, so yeah, I think this is also a very important part of Section 230. Would you say?
absolutely, yeah. And yeah, it's interesting that you say that thing about free speech, like because it kind of begs a question, like is Section 230 a free speech law, or is it a law that allows for censorship, kind of? And what I would say is, and let's go through this section. Basically, what this section is saying is that the providers of these interactive computer services are allowed to take action, and there's some pretty key language here, in good faith,
Mm-hmm.
and then it basically says they can moderate things that are obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise. Now, here are some really important terms: in good faith and otherwise objectionable. Like Section 230 is pretty short, and these kind of vague things, they're saying that platforms have to say in good faith they have to be doing this moderation, and like these obscene, lewd, lascivious, excessively violent, harassing. These are all kind of like pretty horrible things that most people are pretty cool with not having on your internet platform. Although I guess edgy humor could be a place where you could have disagreement. But this otherwise objectionable is like a really that's going to lead to some of the controversy that
That's
we're going to
so
talk about
open-ended.
later. Yeah, it's so vague. And what's interesting is because this was written in such a rushed way, and because it was written in such like kind of it was like a very short law. It's pretty open to interpretation sometimes, and
Right.
that's where the courts come in, and the courts have real power and real influence in shaping the law that Congress passed, and actually delineating what it
Yeah.
says. And we'll go through some court cases. But yeah, this is basically saying that, like you said, what is this a free speech law? Is this not a free speech law? It's really taking the stance that the companies or providers of internet services, those are the ones who get to make these decisions about what should be taken down and what shouldn't be taken down, and they cannot be held liable for making those decisions. So it basically gives them the freedom, I guess, the freedom to moderate, and moderate their websites how they see fit. But it could be argued, and I think is pretty successfully argued by some people, certainly on the right nowadays, that they have kind of taken this provision and they've used it to basically censor content that really isn't that objectionable, and they've kind of gone too far with the censorship, and maybe we need to be very clear in this section about what we're talking about. And yeah, we'll get
Hmm.
to that as we discuss later, uh, you know stuff about that. Okay, we'll quickly go through the other sections. They're not as important. Section A is just kind of talking about how the internet is really important, and how it's a big advance for people to learn a lot about things. Users have a great degree of control. True
Hmm.
diversity of political discourse. This is an important one because this arguably is being threatened nowadays. I certainly think so. And then other things over here, they're flourished. And this is kind of just saying that Congress, it's saying kind of Congress's reasoning behind the internet, and them legislating around the internet. And though this isn't really a legal part of the law, like this isn't going to be like used to like in a lawsuit or whatever, it provides judges with kind of some background as to what the reasoning behind the law was, so when they come to interpret it.
Hmm.
And then policy, this is along those same lines. It's saying the policy of the US around the internet. They want to develop it. They want a vibrant and competitive free market. They want maximize user control over information. So the idea being that users are able to kind of control what they receive. Although it's questionable, as we've talked about a lot in the class, it's pretty questionable to what extent that is true. And then they also are some exceptions. that we want to punish actual like crimes being committed on computers, and that's where sections D and E. So D is saying some exceptions. Most notably, it's talking about um, content is harmful to minor. Well, content harmful to minors. Like the idea is that you should really be like reducing that content, but um, there are certain areas like criminal law in section E here, criminal law, intellectual property law, state law, and sex trafficking particularly. And sex trafficking is going to become a major issue with Section 230 later on. So all of these are kind of exceptions where Section 230 can't be just used as kind of a blanket coverall to get out of jail free card.
Mm-hmm.
Like you still have to respect copyright law, you still have to respect sex trafficking law, and you still have to respect privacy laws. And then also states still have a certain level. Obviously, in the U.S. system, states have a lot of power, so they still
Mm-hmm.
have a lot of power as long as it's within this section because federal law obviously supersedes state law. And then the last section F is just defining all the different terms in it. But all in all, this is a very short law. Like it really is not that long,
Mm-hmm.
and essentially for a while this became the standard. This became what created the internet as we know it today. And think about it, of all the top websites that are used nowadays, so many of them like Facebook, Instagram, TikTok, YouTube, so many of these websites rely on user provided content. Yelp, eBay. So this law really gave those companies the free reign and the elbow room that they needed. But the law itself is not always going to protect you. Like you really also need the courts to kind of define it.
Right.
So this is where we can kind of get to some interesting court cases.
I think
Uh,
before getting to court cases, I do want to talk about a little bit like real world impact.
oh,
Something
sure.
that I think everyone knows a little bit more about because I think court cases it's not as sort of well broadcasted, I would say, but
Right.
like maybe this is more targeting the younger audiences because when you were mentioning about the section C2 being able to moderate content, this reminded me of like uh, Donald Trump, which is our president right now,
For
being
sure.
deplatformed from all these social medias back in 2021, I think, if I'm correct, right? Because there was a
Right.
time he was booted off all social media, Twitter, well, now X, but former Twitter, um, all like the Meta products, Instagram, Facebook, and yeah, it was very interesting. Specifically on Twitter, if you can pull up two of his like the two tweets of his latest or the latest tweets before he got booted off, he said something along the lines of that was this was after the Capitol riot, saying basically Trump's supporting these people and saying that um, also this was post election, saying how the election was actually rigged. That he was showing support to the people who voted for him, and
Do
we
you
gotta make
have do we have
America great
a like
again.
yeah, sorry,
Yes, yes,
yeah,
we
let me see if
do.
I'm trying to find those actual
Let
tweets. I
me
remember something about like him telling them to peacefully and patriotically do something.
he
Let me see if I can
to
find.
quote
Here are the
unquote
tweets.
to quote unquote his last two tweets. The first one was the 75 million great American patriots who voted for me, America first, and make America great again, will have a giant voice long in the future. They will not be disrespected or treated unfairly in any way, shape, or form. The second tweet was to all those who have asked, I will not be going to the inauguration on January 20th. And that was the last tweet that President Donald Trump was able to send. And then Twitter booted him off the platform. And the reasoning was um, basically Twitter said the tweet
Oh, here we go. I found it.
concerning it.
Here. These
Yeah,
are it. This is the
basically,
language.
yeah,
Yeah.
that one, exactly. Basically, Twitter said tweets concerning inauguration could be viewed as a further statement that the election was not legitimate. It also said that the tweet could be interpreted as Trump saying that the inauguration would be safe, a safe target for violence because he would not be attending.
hmm
And basically Twitter said it violated the community law, community guidelines of further incitement of violence, and that is
Right.
why he got booted off. So this to me was very interesting because from what I was able to read from the tweet, there was nothing in, inciting at all to me, which was also very interesting. And Facebook also came out later, um, booted off President Donald Trump for violating the guideline called Community Standard on Dangerous Individuals and Organizations, which is very interesting to me as well. Basically, it violated the rules of not being able to praise or support people engaged in violence.
Right.
Um, yeah, which is very interesting to me. So I think I don't know. I feel like this with Section 230, this is sort of enabling platforms like Meta and Twitter to restrict the content on their platform, which plays into Section two C2. Giving platforms the power to moderate, right?
Right. Yeah, and I guess this it really kind of speaks to yeah, this was also a pretty crazy. Let me see if I can find a little archive of see a lot of this. Um,
This is quite new already. I can send
Yeah,
you the link.
these
Let
are
me see
too
if I can
recent
send
because
you
he
the link.
got added back eventually. But yeah, there were a couple of really shocking things to me about like kind of the Twitter ban. One of the things is that he was not just banned from Twitter, right? He was banned from like a ton of different
Almost
platforms.
all mainstream social media. Yeah.
Exactly, and it happened like all at once. I mean, obviously, it was an incredibly controversial time. You had basically it was January 6th, which was, according to
Hmm.
some, a riot, according to some, an
Right.
insurrection. This is definitely not a not a fun time in the country. Um,
Yeah.
but it it was pretty shocking in that it was the first time that someone had just kind of booted the sitting U.S. president off. And what's interesting is if you, like you said, if you look at these tweets, I even remember from that day him posting, uh, like, something like peacefully protest, respect law enforcement. Do you remember like some tweet like that? Trump tweet,
Yeah. I think this
respect.
was after the George Floyd case.
Yeah, so something like this, like please support our Capitol law enforcement. Truly on the side of our country. Stay peaceful. Like there's these tweets that he sent out that weren't like directly really calling for, violence, or they weren't like expressly doing things, but these are kind of these weird decisions that these platforms make sometimes. But this was a
Hmm.
very controversial, like you said, and it led to like um, a real re-examining of like, oh, how do we really want these platforms to be deciding these things? Like, did they decide correctly? Did they apply
Right.
their standards? And I think it speaks more broadly also to the issue that like a lot of these companies are very like weird about how they moderate. Like the idea was supposed to be that they kind of moderate with whatever the sensibilities are, of the general public, but it's not so clear to me that they do that. And this was obviously kind of the most famous example of kind of like a pure deplatforming, just removing from every social media. And it ultimately turned a lot of conservatives, and particularly a lot of like the MAGA conservative, MAGA right,
Hmm.
really like they started to sour pretty quickly on Section 230 and some of the protections that these platforms have. Because
Yeah.
under Section 230, Twitter was totally within their rights to kick Trump
Yeah.
off of their platform. And
And
they didn't just kick him off on a day. This was like a permanent ban. They banned him forever
oh yeah.
from the
Yeah.
platform. And they banned also at the time, they didn't just ban him, they banned I think a crazy number of 70,000 or something accounts that agreed with him. And then ultimately he was added back after obviously a few years later, Elon Musk took over the platform and changed it to a more free speech centric platform.
And
Um,
also very interesting, that the initial Meta Facebook ban was also indefinite, but then
Right.
they reinstated. And then apparently Meta, they have like this their own oversight board to make sure the content that being posted on Facebook is legal, is within the as well within the boundaries of moderation and etc. Yada yada yada. And then that oversight board actually deemed the well, they upheld the ban, but they said the indefinite ban was, I think, illegal or not up to standard. So instead, they did like a 2-year ban, and after the 2-year ban, they reinstated Donald Trump's account, saying that to assess whether there's a serious risk of public safety that existed in January 2021 has sufficiently receded. We have evaluated the current environment according to our crisis policy protocol, which included looking at the conduct of the U.S. 2022 midterm election, the expert assessment on the current security environment, and then they have decided that the risk has sufficiently receded and that we should therefore adhere to the 2-year timeline that they have set out,
Right.
which is reinstating President Trump's account. So I
Right.
think it these tech platforms, although I think Section 230 granted them this power of being able to moderate, but I think they are still acting well within the boundary of what is being, I think, what should be considered, um, I guess, common sense or
Right.
some
Right.
sort. Yeah.
Yeah, and it's very interesting, like who they decide. Like a lot of these people, like on this board, are like professors and judges and stuff. But this is definitely like a very kind of elite group of people. Former Prime Minister of Denmark, Vice President of the Cato Institute, which I think is a libertarian think tank. So they tried to get kind of this like cabal of experts to basically kind of make their decisions over like final decisions, but um, it was still seen as like it's still often seen as being like kind of biased in one way or another. The expert class is seen as biased to the left sometimes.
Yeah.
So this also like we see that some of their forms of moderation and governance that they try to come up with internally, these companies are still kind of quite controversial, particularly in today's kind of polarized political climate.
That is
Are there any
true.
other like good cases of deplatforming? Because deplatforming is like a big thing that everyone's kind of heard about.
Yeah, yeah. Like you mentioned, there is this trend of more like right-wing public figures being banned more often than left wings. Um,
Yeah, definitely.
as we can see, Alec Jones, which he's like a far right actually conspiracist. He was booted off Spotify, Facebook, Apple, basically saying that he violated the guidelines of promoting, advocating, or inciting hatred or violence against groups or individuals based on characteristics.
Right.
Basically, I think it's just racism in short.
Well, when
Um,
I remember this ban happening. I think it was before the Trump one, right? When did it happen?
yeah, this was 2018, I think.
Yeah, I remember
Yeah.
it was just the biggest news story for like a little while that Alex Jones was basically the platform. And similar to Trump, like we said before, it was all the companies at the same time deplatformed. Then we got the
Hmm.
platform from Apple, YouTube, Spotify, but not just those, even like utility companies, I think banned him, like PayPal and stuff. Like maybe his
Interesting.
bank dropped him. Like it was like everyone kind of at once just threw this guy off their platform. Um, I don't know.
Yeah.
I guess a lot of this is like Alex Jones is definitely not like he's not Bert and Ernie from Sesame Street. He's a pretty controversial guy,
Yeah.
but this kind of speaks to like what are we willing to allow on our platform and like how free speech centric are we if we're also kind of kicking people off? What is that objectionable material we're talking about? And to what extent are people kind of protected by, satire and stuff? I don't know. To me, Alex Jones is more of like he's like half comedian, half pundit.
Right.
He just kind of says like insane shit, and it's pretty funny oftentimes. I don't know if you've seen like the frickin' frog's gay, the frickin' frog's gay.
I don't like them putting chemicals in the water that turn the friggin' frogs gay. Do you understand that? Turn the friggin' frogs gay. Serious crap. Gay. Frogs, friggin' frogs. It's not funny. I'm gonna say it real slow for you. Gay. Frogs. liberal. Liberal, 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 liberal. Happy fun, la la la. Human smuggling, fentanyl gas. Forced government euthanasia, chopping up children's genitals, la 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 la.
Like clip or
I actually
I
don't.
remember it.
I wasn't following this case
Right, I followed
a
it a little
lot.
bit, just because it was pretty surprise. I don't know. Personally, I think deplatforming is a big issue.
Well, I
But
think this is still something very subjective to the platforms. I
for
think
sure, yeah.
what we should look at is actually some court cases. I think when it comes to court cases, during trial, it'd be more objective. I don't know if there are any sort of well-known court cases that involved Section 230. Would if you have any examples.
Yeah, there definitely are. Just to close off on the Alex Jones thing at one point, though, it's interesting because like this kind of trend of deplatforming a lot of these big figures, and someone like have you ever heard the term Overton window said before?
No,
So
no.
Overton window is like it's like a sociological concept of like what is the kind of range politically or otherwise of like discourse that we consider acceptable to talk about in society, you know?
Okay.
And this Overton window kind of dictates like what is kind of socially acceptable and what content basically needs to kind of go to the side. And kicking off Alex Jones, a very fringe figure, while it was seen as like a big issue by free speech centric people, um, like myself, there are people who you could definitely make the argument that he's a controversial, possibly bad person for doing different things or saying different crazy things. But someone like Trump, who was also controversial, is a much more mainstream figure. I mean, he won the last election with
Right.
the popular vote. So
Right.
are these platforms, this is something to think about and something for the audience here to think about, is are these platforms keeping within these these reasonings behind this law, the reasonings of having a diversity of political discourse and avenues for intellectual activity? Like, are you keeping within that ethos
Mm,
if
I
you're
see what
kind
you're
of kicking
saying.
off mainstream right wing? And generally, I think the platforms, something you see from all of them kind of kicking off people at the same time and kind of coordinating on that is that a lot of them, up until maybe recently, were very ideologically similar at one point and kind of acted in unison. And this could be an issue. This could lead to shutting down opinions that may not be all that controversial if most of the
Mm-hmm.
country can get behind at least aspects of them.
Mm-hmm.
And certainly this happened quite a lot, and ultimately I think led to the big Elon Musk shift, the seismic shift with Twitter. I think was prompted by a few of these kind of cases, maybe the
Makes sense.
Trump case, but also I think when he talked about, I don't know if you saw like him kind of talk about the reasoning for uh buying Twitter. Did you follow that at all, Marco?
I think it was just free speech, right? Basically,
Right. I mean,
giving a platform for.
for like free speech folk, yeah, he's definitely a
Yeah.
free speech absolutist. That's like a self-professed thing that he is. But I think there were two cases. One was the Babylon Bee. Um, I don't know if you're familiar with the Babylon Bee. It's like it's like uh, it's like the Onion for conservatives, basically, kind of like a Christian conservative version of the Onion. And they were kicked off for making a post about something having to do with like kind of gender ideology, transgender issues, and then also I think Jordan Peterson, the famous right wing or
Mm-hmm.
conservative classical liberal Canadian psychologist, was also kicked off for a similar thing, for a similar
Interesting.
like gender ideology related attack on kind of the left's gender ideology stuff. I think it was specifically pertaining to an actress who was like transgender, Ellen Page, the actress from Inception. But these people were kicked off Twitter essentially for saying things that, while they're definitely controversial, uh, broadly speaking, a huge number of people in the country would get behind and agree with. So
Mm-hmm.
this is something to think about. Like, are these social media companies effectively using the powers that we're giving them to basically be the arbiters of what is and isn't allowed on their
Mm-hmm.
platforms? And to what extent does the internet serve as a place where everyone should be able to kind of say their piece, and serve as a town square for everyone? And certainly nowadays, it's just the most widespread way that people communicate with each other, and the platforms that we have are so kind of entrenched, and they're like really, we don't really have too many alternatives, and the alternatives are very small, and most of the development has gone into these main platforms. They're also very good and very useful and have a lot of cool
Hmm.
features. So there's kind of stuff going on there with that. So all these questions kind of come up and are important to think about. And I think other episodes that we have will focus more on that. But yeah, let's move on to now to the kind of court cases centering around Section 230 and some of the interesting ways that it was interpreted by the courts. So over here, uh, the points I want to make about the courts is that the courts have basically kind of had a few phases. The courts have generally been very broad and expansive in the way that they viewed Section 230, and they really made Section 230 very robust in the early years, in the first kind of decade of Section 230 existing, the 90s and the early 2000s. The first case that came up, which is a very famous case, was Zarin versus Zarin versus AOL. This was in the Fourth Circuit Court. Let me get you a circuit map of the courts. The circuit map looks like this. Let's see if I can open this in a new tab. So um, each of these is an appellate court for the federal courts, and the Fourth Circuit over here is where the first kind of issues came up. Something that's important to note as we talk about court cases is the one that you should mostly care about if you're talking about tech companies is the Ninth Circuit. You see how the Ninth Circuit covers like this insanely large swath of
Hmm.
the Western United States? Most tech companies are here. Most tech companies are based in California,
Right.
Washington. Like this is where tech companies are at. It's basically California, Washington are like the two biggest like tech company, home bases. So whatever the Ninth Circuit court says is very, very important. But the first court to really take up Section 230 was the Fourth Circuit in a case called Zarin versus AOL. Right now, Zarin versus AOL, it really talked about someone who sued American Online. This guy Zarin, who sued American Online because basically someone as like kind of as a satire basically linked him to the Oklahoma City bombing, which was like a big terrorist attack that killed a lot of people. Um, and they linked him to kind of selling merch about the Oklahoma City bombing. Um, Let me see. Maybe I could get like some examples of what this merch was. Sarin versus AOL. Um, it was kind of a scam, like a kind of like a scam where they were kind of putting these T-shirts that said like crazy like slogans, naughty Oklahoma City T-shirts, which had like offensive slogans. Uh, to be honest, one of them I thought was really funny when I was reading about this case. I'm trying to remember what it was. Wonder if anyone has like a listing of the actual slogans. But regardless, um, this caused him like a lot of headache. Basically, people were kind of calling him and screaming at him, and he was getting kind of harassed because people thought he was kind of like making fun or being linked to this terrorist attack, when in reality he had literally nothing to do with it. They just kind of plucked him out
Hmm.
of a hat and put his like name and phone number and personal phone number all over this, and he couldn't even change his phone number because he used it for his business. It's a very rough case for this particular guy, and ultimately, even despite this guy being like really harassed because of this, it was ruled in the courts pretty clearly that Section 230 broadly protected this guy, even despite the fact that these ads were libelous and that they inappropriately had his home phone number. It was found that AOL could not be held responsible for this,
Interesting.
and it would have been caused like chilling effect on the internet, and it was just generally seen as like a very expansive reading of Section 230 that didn't try to limit Section 230. There were people that argued that Section 230 should have been more limited in that its consideration of people as not publishers or speakers maybe should
Hmm.
have still constituted some sort of like stuff that you'd have to do, like some sort of stuff that you'd have to take down. Like you should still have to take down things in You should still have to take down things if you know it's illegal, for example. But they
Hmm.
were pretty broad, and they were saying no. And the judge in this case basically said no. Congress made a conscious decision that they want to increase like free speech and they want to increase diversity of opinion. So we're going to be pretty expansive about what we allow on here. And there were other cases that came after that that continued that scenario. A controversial one, Batzel versus Smith. This was like a woman who had a contractor who like helped fix something in her house, and they had a falling out. And he sent an email to like a list serve of like stolen art for a museum in Europe or something, and basically accused her of being like a Nazi's granddaughter and of stealing art and of having stolen art that belonged to Jews in the Holocaust, right? And
Interesting.
this was like totally not true. But this guy essentially took this email, edited it, like said some stuff about it, and then posted it to this listserv. And it had like this woman's private information too. And basically, the
Hmm.
woman, this like ruined her life. It like caused her to lose all her business. She was like a pretty prominent lawyer at the time, and it caused her to lose kind of almost everything that she had. And she sued this listserv. And it was also, this was notable because it was very small. It was just like 1,000 people. And she sued them, and Section 230 was found to protect this listserv, and this was a case also in the Ninth Circuit. This was in the circuit that has like internet law, which kind of governs these states and is
Hmm.
binding for these states, and it ultimately protected this listserv, and this was seen as pretty crazy. What's crazy is because the guy who posted it, it was very small group, and the guy who posted it actually changed the email and edited some things and wrote like an introduction to it. So he did some pretty transformative work to the thing, which
Right.
you could maybe argue that he was one of the speakers, but ultimately it was ruled in the internet company's favor. What's interesting is that Chris Cox, one of the original writers of Section 230, actually hates this
Hmm.
case and was very upset about this because he was like, it shouldn't have applied here because the guy
Interesting.
changed stuff
Right.
and it
Right.
wasn't. What do you think? Do you think that it should have applied in a case where like the guy maybe changed stuff and altered aspects?
Uh, See, this is very tricky. I think with Section 230, it is so vague and it's so up for interpretation. Like, I think
Right.
you can argue both ways. Um, uh, yeah, I don't know. I mean, do you have a strong opinion?
Yeah, I don't know. It's tough to say. It's really hard to say. Also, you have to look at, I think, the particulars of the case, which surely the judges did. But definitely in a case where the actual publisher is particularly changing content, there's already room to kind of argue both ways. But it was just a very interesting case, and it really showed the courts were ready to kind of back this thing full throttle and
Hmm.
basically say, Section 230 really, really, really protects these internet platforms
Yeah.
and really allows them a lot of room. And there were some other cases as well. Carafano versus Metrosplash. Carafano she's actually an actress. Uh, she was an actress in Star Trek. What's her name? Let me look up her name here. Chase Masterson is her name. This is a famous actress in Star Trek, and Metro Splash was kind of like a dating website, and someone made a really fake, really nasty profile about her that led to her getting a lot of harassment and like really nasty harassment to her and her like small kid that actually like people like men were coming up to her and saying very like sexually abusive things and leaving her really like vaguely threatening phone calls and stuff, and led to her actually having to leave where she lived and go live in a hotel because she was like scared. um but it was viewed as no, it's still okay for this dating platform to have done this. I mean, it's not okay, but they couldn't be held liable for
Yeah.
something someone else did on their platform. And this was even despite them. It was they tried to argue, the Carafano's lawyers tried to argue that the dating website, by offering fields to fill out, maybe they have some sort of publishing aspect, but this was rejected by the courts. So the courts were very expansive in the protections. And then there were similar ones. There were a lot of Doe cases. Doe versus America Online, Doe versus MySpace. The Doe versus America Online was particularly really nasty case. This one is probably the most controversial case of basically someone like a small young children who are having sexual images of them, like really nasty, like child pornography being trafficked on certain websites. And basically it was held that even if this material was particularly awful, you couldn't hold these companies liable. So there were some very strong protections for Section 230. And then
Interesting.
ultimately, 230 started to be eroded in the courts a little bit. And there were really two big cases that eroded it in the courts, and then one big case that was so huge that it eroded kind of the whole thing altogether. So the two cases that eroded it were, there's one called Fair Housing Council of San Fernando Valley versus roommates.com. And this basically, roommates.com was a place to find roommates and listings, but roommates.com was the government basically sued them for basically saying they were violating housing laws in terms of like ethnicity and race, because you could put like what race you wanted to be roommates with and what age you wanted to
Mm,
be roommates with and whether it was a man or a woman. Like you could put in like certain preferences that may be illegal under housing law. And at this point,
interesting.
the courts started to kind of turn a little bit. Public opinion started to shift. At this point, these big companies with internet companies were no longer the little players on the block, the little developers. These are were now growing to be pretty big, powerful companies. And in this
Hmm.
case, the judge actually ruled in first it was the three-judge Court of Appeals, and then ultimately they did an en banc ruling on appeal, where the entire like a very large swath of the appellate courts. And this was also in the Ninth Circuit, like we said. Most of the internet cases are in the Ninth Circuit. So this is a
Hmm.
very big, very important ruling. And this ruling basically said that roommates.com, by offering these fields and by requiring them when you fill out what you wanted your roommate to be, they were actually contributing materially to the illegality. And this basically eroded Section 230. It basically said that they could be held liable for things that were posted on their website by someone else because of the way that they were phrasing these questions and because of the way they were requiring some of these questions. And this was a big kind of reversal, a little bit of, in a sense, of the Section 230 kind of status quo. And it led to a lot of concerns that this would ultimately be chilling for free speech and that you would have, companies that were afraid to post things because then they might be held liable due to these like kind
Hmm.
of particular concerns. What's funny is a lot of these cases kind of end in nothing. Like this case ultimately got dismissed because it was found to not actually be a violation of housing law. But it wasn't even that. It was kind of this aspect of the case that became like a very important thing. And then
Hmm.
there's also one called Barnes versus Yahoo. This is a revenge porn case. This woman, Barnes, her ex-boyfriend posted basically all of her nude pictures and sexual pictures onto Yahoo. And Yahoo didn't take them down despite her calling and trying. And then she finally called them and she got a hold of a service representative and she was like, "Take down my nude pictures. Like this is a serious problem." She submitted all this stuff. They never answered her. And the service representative said, "Okay, we'll take them down. I promise you, I'm going to go right now and I'm going to take them down." And then for months after that, they still didn't take them down. And
Interesting.
yeah, and then they sued and they tried to argue Section 230 protected them because it's like, oh, this other person, this ex-boyfriend posted the content. But ultimately it was actually ruled against them because it was ruled as a case of promissory estoppel, which is this kind of idea that they had almost like broken a contract where because they had agreed to take down the content and they didn't follow their word to take down the content.
Hmm.
This led to basically them violating they no longer were protected under Section 230 because of this, because they said that they would take it down. She had a successful case because she kind of stopped doing stuff to prevent it once they had promised to take it down, and she was harmed as a result of that.
Hmm.
So these cases are pretty interesting, and a case like that, even though that kind of makes sense, it might have a chilling effect, and that it might lead companies to not respond if you have issues and you want
Right.
something really bad taken down, because now
Right.
it's in their interest to not say anything, because if they agree to something they could then be held liable later. So all these cases have like all these kind of crazy downstream effects for how the internet could work. Even if it's not the particulars of the case go one
Hmm.
way, it could be used as a basis for something new. And then ultimately, there was a really, really big controversy that actually led to Section 230 being materially changed. And this was Backpage. Backpage was a website, kind of like Craigslist, but it ultimately had a lot of like sex escorting parts to it. And it was basically found by a lot of different state governments that Backpage was being used to do sex trafficking of like young girls, and it really horrific stuff. But Section 230 was basically effectively applied to protect backstage Backpage, as long as they weren't technically creating that content, even if they were, and it was argued in court, I think pretty successfully, that they were really being very irresponsible and not taking steps to
Mm-hmm.
block this kind of content. They were even encouraging it. And
Right.
Once like Craigslist shut down their like sex escorting thing, they kind of were like, oh, let's go get this. And one particularly horrific thing that they did was they would take posts. If someone posted a post that was clearly advertising like sex with a minor, they would remove words that had to do with minor, but then they would just post it anyway.
Is this
They would
Craigslist
like,
or was this
this is
Backpage?
Backpage, which is insane that they would do that. But they would literally just remove the word like young or virgin or whatever it is, and then they would just post the rest of the post and still let it go through on their website. So they were being extremely irresponsible, and likely doing very illegal, horrific things. And this led to a lot of outrage. But because of Section 230, ultimately protected them in the courts. And then this was seen as such an outrage that it actually went to Congress, and Congress got really upset about it, and ultimately got made into a law called the name of it was kind of interesting. It was like Sesta FOPA, something like that. Let me see if I have it written down here.
That's very
Um,
interesting.
FOSTA Sesta, that was the name of the law. Uh, FOSTA SESTA. It was the allow states and victims to fight online sex trafficking and stop enabling sex trafficking. So this was a law that was basically supposed to block this sex trafficking. Basically, it carved out an exception in 230 that made it so that Section 230 wouldn't apply to
Mm,
this sex trafficking.
yeah.
But also there were some issues with that, and that the exception was also a little bit broadly written, and that created a lot of issues and may have chilled some free speech and may have led content providers. I think Craigslist like shut down their like the dating part of their website because they were worried about, because if it's possibly used for sex trafficking, they could be like liable, and
Mm-hmm.
they basically had to shut down the dating part of their website. So this had like downstream effects,
Mm-hmm.
that are a thing. And I think ultimately a lesson that was taken from that from people who like Section 230 is that if you want to carve out exceptions, they have to be very, very, very specific. Like you really should make the law as specific as possible to say you should if it's knowable sex trafficking and they're clearly taking steps to try to do it, then it's a problem. Ultimately,
Mm-hmm.
Backpage was shut down. The FBI arrested the people running it, and they pled guilty to federal sex crimes, which were never covered by Section
Interesting.
230 anyway. But this created a lot of controversy around what we're allowing. And even though Section 230 protects these platforms from allowing some pretty horrible content, I think we can pretty universally agree that child sex trafficking is a big problem.
When
It's
was this
something.
Backpage case? When
I
did it
think this
happen?
was 20. It was like the court cases were in the 2010s, but ultimately
Mm-hmm.
it came to a head in 2017. Was like really when that law was passed.
Interesting.
And there was a hearing in front of Congress with Chris Cox, the writer of the original thing and the author of the
Mm-hmm.
book, of that great book that the 26 words that created the internet, and they were arguing about whether there should be a carve out for this. And then that's kind of like the most recent legal change to Section 230. Other than that change, Section 230 is still the law. It's still fully the law,
Mm-hmm.
and these court cases broadly apply. But there's one other case that we really should discuss, which is terrorism. There have been a lot of cases about terrorism because there are laws in the U.S. saying that you can't aid and abet terrorists, but
Mm-hmm.
some of these platforms have been used pretty successfully by terrorist organizations. ISIS notably did recruiting on Twitter, and was kind of used. Twitter ISIS used Twitter a lot to do some of their things, posted their beheadings and all sorts of crazy stuff
Mm-hmm.
on Twitter, and I believe there was Facebook also was used for some stuff. Force versus Facebook. Facebook was used for like stuff concerning terrorist groups like Hamas in the Middle East and other ones, maybe Hezbollah. And then there were other ones like Gonzalez versus Google, Twitter versus Tamna, and Fields versus Twitter, which was people who were murdered essentially by terrorists. And it was argued that these social media companies, by allowing these terrorists to operate on their platforms, were somehow responsible. And ultimately, these cases were protected using Section 230. And for the first time, most of the cases we talked about in the district courts, and district courts are only binding in particular areas. Like a district court ruling in the Ninth Circuit doesn't necessarily apply to the Tenth Circuit or any other circuit
Hmm.
unless they decide. Unless those judges are kind of free to disagree and come up with their own rulings that are then binding for their states. But the Supreme Court is kind of binding for the whole country. So the Supreme Court actually took up those cases with these terrorists in 2023 and ultimately decided in the two cases, Twitter versus Tomna and Gonzalez versus Google, they ultimately decided in the social media company's favor and said basically Section 230 protects this kind of content. And they also said that the plaintiffs couldn't really make a good case that Twitter had like actively tried to help these terrorist platforms as
Hmm.
opposed to just letting them on and maybe not moderating heavily enough. Although it's kind of funny to think that Twitter views ISIS as less problematic than the current president. It's
Yeah.
pretty pretty crazy turn
Yeah.
of events there. But that goes to show you that Section 230 is still really powerful and still can really protect these internet platforms in these cool ways. And I guess do you have any ideas moving kind of forward from these big issues of deplatforming and these big issues of the legal cases? Do we have any kind of ideas, Marco, or do you know anything about kind of the current status of Section 230 and like whether there's anything fomenting for it to be reformed or anyone trying to kind of change it?
Right, right. Yeah. So I think with the current issue, I think what we've covered with the cases, it's pretty obvious, right? Because it's quite ambiguous. It's really like open-ended. It's really up for interpretation. So I think what a couple of like the most prominent issues is ambiguity and its broad interpretation. Second would be the the law itself, Section 230. It, like you said, it didn't really take into consideration all the exceptions in extreme cases such as human trafficking, terrorism, child pornography, drug sales, cyber stalking. So these would be specific cases or extreme cases that me personally think that should be included in Section 230 as exceptions. And yeah, and again, there's always this constant debate of platform versus publishers, and whether that should also have a very like clear line of definition. But yeah, you mentioned reforms. There have been definitely attempts to reform. We'll start from fairly recent, but in chronological order. In President Trump's first administration, he actually signed a order to direct federal agencies to review Section 230.
Right.
This sort of stemmed from Trump's and his allies. They got very furious over how social media was censoring their posts, their content. Twitter began flagging Donald Trump's fake tweets about mailing votes, and sort of also other incendiary comments around the racial injustice protest that followed the George Floyd incident. Um, so yeah, during his administration, Trump signed a order to over sort of review Section 230, but this was then later revoked by President Biden, just a
Right.
year, less than a year into his administration. So that didn't really do anything. Um, and there has been this, and this was one thing. The second sort of attempt was this act called Safe Tech Act. It was first introduced in, I think, 2017, and it was again reintroduced in 2021 in the 119th Congress, in both in front of the Senate and the House. Basically, this is an attempt to make tech platforms more liable, increase their responsibility, helping them hold them more accountable for the content that is being posted on the platform. But
Right.
this act is still in motion. It has not been passed. Neither the House nor the Congress have reached consensus. And the most recent attempt is a bill that is still, I think, being drafted. It's spearheaded by Senator Dick Durbin. He's a Democrat from Illinois, and Lindsey Graham. She's a Republican from South Carolina. Basically, they are saying that Section 230 is outdated. We should have a new law in place of Section 230 that sort of resolves all the ambiguity, um, the aforementioned exceptions, taking all those into consideration. But one of the problem, or the forever lasting problem, is like you mentioned during the passing of Section 230 at its very original time, people didn't really know what it was, and internet wasn't really a thing, so people didn't really pay attention to it. But right now, internet being the cornerstone to a lot of like people's lives these days, the right wing and left wing have sort of drastic opposing opinions on what to do
Right.
with Section 230.
Right, but
Um,
what's interesting almost is like even the fact that they have drastically opposing opinions, they still kind of agree on, they still are starting to kind of come to, it seems, maybe a consensus that Section 230 as it is now has problems. But they kind
yeah,
of wildly disagree on what those problems are. Like the
exactly.
problems that they each see with it are crazy, but just the just the fact that they agree could lead to enough bipartisan consensus to actually change the law in Congress. Like there's nothing other than Congress that makes Section 230 possible in the first place, and they could just as easily get rid of it, you know?
Yeah, I think this is definitely, but this is definitely true. But at the same time, reading like sort of the right and the left opinions or viewpoints on what should be, Section 230 is sort of, I wouldn't say disheartening, but to me, it's like very hard for, I think, a bipartisan law to be passed because basically, putting it in short, the left wing, more Democrat, think that the platforms should have more control over the content and what is being posted, and therefore holding more like liability. And the
Right.
right
Like
wing,
they like in a sense they want them to they hate like the left is very up in arms these days about disinformation, what they call disinformation, what they call
right?
misinformation, election interference, etc. So
Yes,
they're very concerned about that stuff, and they want the internet platforms to be kind of forced to deal with that more than they are, you know.
yes,
They were
exactly.
very upset around the time, particularly around 2016 when Trump won his first time. I think the left kind of was so shocked that he won that they like almost blamed the social media companies in part and Russia in part.
Yeah,
And that led to kind of a lot of skepticism of social media companies and of Section 230 protecting them from having to take down certain things. So they kind of want the government or the law to maybe force them to take down more stuff. Right. And but
yeah.
what's the right wing opinion that
Right.
would kind of
So,
differ from that?
on the opposite of left wing, they want the platform to basically have more control. You can call it censorship if you want, but having control over what is posted and what is not. And the left wings, sorry, right wings, they think right now platforms um, have this sort of ominous power. Like platforms are omnipotent, right? They have
Right.
control over the user, the content, the topics that are being posted. So the right wings think they should the platforms, the companies should interfere less with what is being posted. So as you can see, right, very different viewpoints, and if
Yeah, and I think
I
definitely the
find it
right, it
really hard,
seems
yeah,
the right like definitely seems like they want like more they want like less censorship. They don't really view like there's an argument that said that kind of by invoking Section 230, a platform is invoking its own kind of speech rights to editorialize content and delete content. But the right doesn't really see deletion of content or censorship as a form of speech. They see censorship as censorship and speech as speech, and they want more speech. And they want the right wing ideas, which were really kind of uh, less in the ascendancy recently, to kind of be equally expressed or be able to be expressed without being taken down. But yeah, what was the thought you were going to say? Marco, you there?
I'm back. Um,
Oh, nice.
yeah, no,
Yeah,
I
seems
totally
back.
agree. Like, but what is sort of what I think is given the drastic different viewpoints, it's going to be very hard to pass a bill that serves both sides, right? I mean, yes, of course, you can add different subsections and different subsections to say a new section 230, but just the viewpoint of whether there should be more control from the platform side or there should just be the more free speech is something that I think needs to be resolved first and reach bipartisan consent. And that to me is something that is a extremely high barrier that we need to move past
Yeah, and
first.
also to pass any legislation, you got to get half, more than half the House. You got to get 60% of the Senate. You got to get 60 votes in the Senate, and you got to get the president to sign. So you have to really have everyone
Exactly.
in agreement. And even though a lot of people agree that Section 230 is bad, which it may not necessarily be, but that's what a lot of people think. And ultimately, I think we have a later episode that'll get into the nitty gritty and into the weeds on that, on like the exact opinions about Section 230. But ultimately, you're going to need a lot of consensus to get rid of it, and if you or get rid of it or replace it or modify it, and those modifications, replacements need to be tempered to, need to have everyone agree to the point where it can pass,
Exactly.
which right
Yeah.
now it doesn't, like you said, it doesn't really seem like that's going to really happen. Over here, this is the Justice Department review that you were talking about before, that Trump convened or
Yeah.
whatever. And you
Yeah.
could see this bad Samaritan carve out, like trying to carve outs for child abuse, terrorism, cyberstalking, trying
Mm-hmm.
to get them to be more responsible for that, clarifying government enforcement, promoting competition. This is kind of where it's saying like federal antitrust shouldn't be sexually covered by 230, especially considering the tech companies, so there are very few of them and they have a lot of control.
Mm-hmm.
But this one I think is really an important one where it talks about replacing vague terminology. Like otherwise objectionable is pretty vague. Whereas if you add something like unlawful or promotes terrorism, you can maybe kind of make the argument that then if you're editorializing kind of mainstream political opinions, maybe that's no longer protected by Section 230. Maybe now you are a publisher because you're
That's
going
true.
above and beyond the simple moderation of like harmful content or really violent snuff films or whatever, and you're actually just getting rid of content that you disagree with, but that's perfectly normal for the rest of society. And then also a definition of good faith, because good faith is very vague. What does that mean? Like, what does it mean to be in good faith? That would help, and then kind of explicit overrules Stratton Oakmont. That's that case that we talked about with the guy who ate the goldfish from Wolf of Wall Street. I
Yeah.
also want to point out where the public opinion is at. Like the public opinion in Pew kind of seems to waver a lot on it, but you
Mm-hmm.
do have 56% of Americans oppose the right to sue social media companies for what they post. So already you do have something of a majority saying that you should not be able to sue, and it's actually more
Well, I
Republicans
mean,
who
I
think
think
that.
56 is somewhat in the middle. That, to be honest, I first time seeing this number, pretty striking. I would have
Right.
thought the number was were to be higher, you know.
Right. And then social media users are more likely this 59%, 47%. That's a little bit more of a bar.
Right.
56% is, yeah, it's more than half, but it's still a pretty close thing. And this was also from 2021, so it's
Mm-hmm.
possible that views are changing. Most
Yeah.
Americans favor restrictions on false information, violent content online, so that's where you're starting to get into something there. And
Mm-hmm.
it's obviously a lot more Democrats than Republicans are thinking those lines. But then here we
Yep.
go, support is dipping now. Now in 2025, this support is not the same way as it was anymore. Now people are
Mm-hmm.
kind of souring on the idea of kind of regulating tech companies to that extent, you know?
Mm-hmm.
So this is definitely a contentious thing. Also, a lot of Americans kind of really don't have a super clear understanding of how 230 works. So this is kind of part of what we're trying to do today to kind of educate people on that. But also,
Yeah.
I think it pays to talk about to what extent, if you change 230 or if you even get rid of 230, sunset 230, like Lindsey Graham has talked about, or if you add so many provisions to 230 where it becomes kind of you poke holes in it to the point where it can't really protect these companies anymore. Like, to what extent can you still have the internet be a thing? And to what extent can these companies still exist? Like, Marco, what do you think? Do you think like that it poses a danger of kind of getting rid of the internet. Like as bad as people think the internet is now, there's a lot of really good things that come out of the internet. There's a lot of really good like
I think,
crowd sharing, a lot of really good communities,
yeah,
a lot of really good
for
crowdfunding
sure.
for things, democratization of information and of voices for news and other things.
Yeah, I think definitely Section 230 is extremely important.
Right,
I think though with the ambiguity problem in like Section 230, I think that is something that can be solved.
right.
With the initial Trump order, it mentioned, carving out some very specific topics that could not be exempt from Section 230. I think with these more specific terminologies and like sort of coined boundaries of what is and what is not legal, I think that could go a long way without disrupting the current internet landscape. So I think there are definitely potentials, but it has to be a very specific and very, I guess, you have to be very specific with what you coin into, this new law that should go in place of Section
Yeah,
230.
I
Yeah.
definitely agree with that. Like, I think that, and we want to make sure to make the point that there is a pretty large move. There is a pretty big movement that also just says maybe 230 is fine the way it is, and maybe we either don't change it at all or we change it very slightly because it's led to a lot of really good things for the economy. Like,
Mm-hmm.
obviously, these internet companies are a huge part of our economy now and a huge part
Mm-hmm.
of, the soft power the U.S. has. And like maybe 230 shouldn't be taken apart, or maybe if we change it very slightly to deal with some of the worst content, stuff like sex trafficking.
Right.
But yeah, like there is a significant status quo argument, and it's made a lot by people like the Electronic Frontier Foundation, EFF, the ACLU, many
Mm-hmm.
other kind of organizations, some legislators. I think like the original writers of 230 still think that it's very important. Certainly others, and I think 230 did. It's important to recognize it did a lot for the country and it did a lot for the development of the internet and allowed so much cool content and so many interesting and useful websites about like kind of real consumer reports on things and like criticisms of companies, criticisms of government. Like it allowed for a lot of really good and content that's really important to our society. So if we change it, we have to be careful that we don't kind of wreck the internet or make the internet even worse somehow.
Oh yeah, for sure, for sure.
Because the internet is an important part of our lives nowadays. So much stuff is done on it. It pays to be careful about how we make it. And I think depending on what you focus on, there's different kind of arguments to be made for either side, and arguments to be made for or against certain types of censorship, or for or against certain types of moderation. But allowing these platforms within existing within the context of a free market to make these decisions answerable to their users, it has led to a lot of really positive things that it's important to keep in mind. As much as kind of the horrific cases like child sex trafficking or pornography or whatever, what have you, overt racism, etc., incitement of
Mm-hmm.
violence. As much as these things may have protections inherent to them, and this may cause a lot of controversy and may make it feel like 230 is kind of taking people's ability to get recompense back, because often in these lawsuits there's no one to sue but the platform, because the person who posted it is someone anonymous who you're never going to find. So if you sue them, you're not going to get anywhere. You might not even be able to track them down, etc. You might not even know who it is in the first place. They might use a VPN, a library computer. So you really have no recourse, and that's kind of sucks for that person. And that person might have genuinely been harassed or genuinely have had their life ruined, like some of the people we talked about. But 230 is important to kind of our discourse. And the ways that we view it in the future, we should keep that in mind and keep in mind its kind of rich history of kind of being very unique among the world. We're the only country in the world that has this kind of protection for internet platforms, and this has led to a lot of good things, and it's important to keep those in
Absolutely,
mind. And
absolutely.
later episodes that our partners have will kind of discuss this in great detail and really battle out the nitty gritty of 230.
Yeah. I think we have covered sufficient grounds in introducing what Section 230 is. Hopefully it was clear to most people. We did cover a lot of information,
Yeah, for
but
sure.
these are all publicly available data. If you're interested, definitely you can look it up yourself. And yeah, we're also excited for our upcoming episodes, which would also include a podcast with a rather well-known, respected professor, which is within this field. Also get some of his expert opinion on this matter, right?
Right. Yeah. And one of the professors from the class, Professor Rushkoff, I believe, is the one who's going to be interviewed. And then also the last one will be kind of a real debate style format where you're going to hear the left, the right, the
Hmm.
status quo, the anti-status quo. You're going to hear kind of maybe all of the opinions, and it's going to be two people kind of battling it out respectfully to try to come to, you can hear all these different opposing ideas and all these opposing considerations that come into the fore for Section 230. And
Hmm.
to build off of what Marco said, if any of you guys have further interest, you can always obviously Google it, but there's some really cool Pew research on this. The book, 26 Words That Created the Internet, is an excellent book. It's really well written. It's very interesting. And all these different cases of deplatforming, there's a lot to look into with, some crazy kooky figures like from Alex Jones
Hmm.
Trump, and then there's many other examples
Yeah,
of this
for sure.
happening. And this is obviously an ongoing thing. Social media is kind of changing. It even feels like the priorities of social media are changing now. Like now, platforms like X and Facebook and Meta are starting to move to a more free speech position, whereas other ones
Hmm.
like maybe YouTube, Patreon, etc., are still pretty firmly in the very moderation heavy camp. I think there's also something to be said for these companies being very clear with what their constraints are, maybe even mandating within Section 230 that they have clear guidelines and clear explanations for people. Like there's definitely room to debate about what the proper ways to handle, internet moderation, internet content delivery um, under 230 are. And hopefully future episodes by our partners will get into that, and you'll get to, see that
Yeah,
and you know have some cool information exposed. And these are things that should make you think, and these are things that are important to the way that most of us are users of these
absolutely.
social media platforms. So these laws really do govern in a very real sense our lives and how we interact with other people and how we interact with ideas. And it's very important. It's very important. Hopefully you guys
Absolutely.
understand the
Yeah.
importance of this law and how changing it might be good or it might be really bad.
Yeah, awesome. Well, I think with that, this would be the end of this podcast, and I
All right,
hope
cool.
everyone enjoyed it. Yeah.
All right, yeah, I hope
Thank you,
everyone
Aaron.
enjoyed. And
Yeah.
Marco, I'll see you.
Yep.
Bye bye.
Thank you for having me.